There's been a key legal decision in a Walton County court case that's been going on for decades. The decision once again finds the Sandestin community out of compliance with its open space requirements. As News 13's Maggie McGuigan tells us, a resident is the one that's holding the county accountable.
Walton County officials have been questioned about the Sandestin development's open space compliance for years. A recent court ruling is providing clarity on the area's stormwater retention and open space standards. Former Sandestin resident Alan Osborne has been leading the charge on the issue. Osborne lived in the Sandestin Driftwood Estates subdivision, an area impacted by periodic flooding for years. Although he sold his property a few years ago, he's been holding Walton County officials accountable for non-compliance. The issue dates back decades. In 1976, the Sandestin Development of Regional Impact, or DRI, was approved. The Sandestin developer and the county created a development standards agreement with the state in 1984. It was adopted by law in 1989 and became the benchmark for stormwater and open space standards in Sandestin. The benchmark is meant to help prevent runoff from flowing into the Choctawhatchee Bay. Osborne says in 2007, the county and developers were notified of violations.
Sandestin is a development of regional impact, meaning the stormwater, the traffic, and the open space can impact other counties, because the bay is connected to Bay County and Okaloosa County, so we have an upstream and downstream neighbors. So anything that impacts that at the time it was approved was a regional impact. And we've had violations of stormwater. The county's been on notice since 2007 and has still taken no action.
In 2014, Walton County found the Sandestin DRI was not in compliance with the development standards. So in 2016, Sandestin Investments LLC, or SDI, submitted a notice of proposed change to meet the open space requirements. The county approved the application the following year. But last month, a judge reversed that decision. A lawsuit Osborne filed against Walton County and SDI found SDI did not provide more open space acreage to address the deficiency identified. In other words, as the lawsuit states, rather than complying with the existing standard, SDI sought to change the standard.
The reason the court case is significant is the judge recognizes the ordinance contains a benchmark that county planning and the developer have completely ignored. They've been allowed to continue to build when they're in substantial deviation violations. And Matt Carpenter, the planning director, has all the letters from the state and engineers and the Florida Board of Engineers stating that the county is applying their own standard in violation.
Osborne says the county could go through the process of changing the stormwater retention benchmark that was set in 1989. But he said it would require the county to admit Sandestin has been in violation of the standard. Meanwhile, Osborne says Choctawhatchee Bay is facing the repercussions of the stormwater violations.
If they change the stormwater, they couldn't take it any less than the state standard. Sandestin is an extremely high standard because, as it said, the intent of the Sandestin Development Order back in the 70s was to protect that great water quality we had in the Choctawhatchee Bay. At the time the Sandestin Development Order was enacted, it was one of the 2 cleanest bays in Florida. And we've lost that.
In Walton County, Maggie McGuigan, News 13, Panhandle Strong.
Osborne says the intent of the development order's higher standard of retention is to prevent contaminants from entering the bay, and forcing a percentage would not be as effective.